Good morning. My name is Anthony Enea. I'm the managing member of Enea Scanlon and Sirignano with offices in White Plains and Somers, New York. We practice in the areas of wills, trust, and estates and elder law. And today we're going to talk a little bit about advanced directives and what is an advanced directive and all the different types of advanced directives that exist. An advanced directive is where you sign a document and prepare a document that gives basically notice to an individual that you want them to act in a certain manner. You're giving a direction in advance of that direction needing to be implemented. So, for example, the forms of advanced directives would be a healthcare proxy, a durable power of attorney or a general power of attorney, a HIPAA form, the Health Insurance Portability and Accountability Act of 2005 form. A living will is considered an advanced directive. These documents are very important because if you haven't executed them, then there are not people appointed to make certain decisions for you, and they don't know what your wishes are. So let's start off by talking about a healthcare proxy. What is a healthcare proxy? Well, it's a writing which is signed and dated and has two witnesses. It's a writing where you select somebody to make healthcare decisions for you when you can no longer make those decisions. So, in order for the healthcare proxy to be used and be enforceable, it has to be a time when you can no longer make your own medical decisions. And you can appoint anybody you want to be your agent under the healthcare proxy. Generally, a husband would appoint the wife, vice versa, wife appoint a husband. If there is no spouse, children, if there are no children, other close family members, siblings, brothers, and sisters. The one thing to remember about a healthcare proxy is that you can only appoint one agent at a time. Many times I see proxies that were signed by individuals and not prepared by attorneys, and they'll have two individuals named as the agents. You can't have two individuals. You can only have one person at a time named as your agent. In the healthcare proxy, you can be as ambiguous as you want about the care that you're going to need if you can't make medical decisions for yourself in the future, or you can be very specific. For example, the healthcare proxy form says that my agent knows my wishes unless they're otherwise stated herein. So unless you specify what your wishes are about the type of care that you want to receive, then it's presumed that you've told your agent what your wishes are. So if you're not going to be specific, it's best to tell your agent in advance what your wishes are about end of life decisions. Do you want to be on a ventilator? Do you want to be on a respirator? Do you want nasogastric tubal feeding? So these are the kinds of things that you have to discuss with your agent. Specifically, it's important to have a discussion about end of life decision making. What do you want to be kept alive on? And under what circumstances do you want to be kept alive? For example, if you're brain dead, comatose with no hope of recovery, do you want to be kept alive? So it's a very important document. It's a document that's recognized by law in New York, and everybody should have a healthcare proxy. It's an extremely important document. And if you're an adult, 18 years of age or older, especially in this day and age of COVID, it's important to have an agent appointed who can make medical decisions for you if you can no longer make those decisions. There's also something called a HIPAA form. That's an authorization for release of health information pursuant to the Health Insurance Portability and Accountability Act of 1996. I said 2005, I'm mistaken about that. I think it was updated in 2005. Why do you need one? Well, it's a written form where you can select somebody to have access to your medical and hospital records. This HIPAA authorization is included as part of the healthcare proxy. In the healthcare proxy form, there is language that says that my agent has access to my medical and hospital records. But there is a separate form that you can use, and that separate form also allows your agent to have access to your psychiatric records, drug addiction and alcohol addiction records, So it's a much more specific form. You can just leave it in the healthcare proxy, but if you want to be much more thorough about it, we always recommend that a separate form be executed. But again, it's really authorizing your agent to have access to your medical and hospital records. Very important. You're sick and you're not being treated by the physician anymore that you have in the past, or you're going to a different hospital. This HIPAA authorization allows your agent to have those records transferred to your new doctors and hospitals. It's the same form that you sign when you go to see a doctor. It's the confidentiality form of your records. A living will. What is a living will? Again, another form of advance directive. Again, this form is not statutorily recognized in New York. It is a writing that's signed, dated, and also witnessed. But this is where you state your intention not to be kept alive by extraordinary measures if you're no longer able to make decisions. For example, if, for example, you're in a coma or you're brain dead, and you've decided, and your agent says, "Look, they told my wife, my husband told me that she didn't want to be kept alive by extraordinary measures in the event that she was brain dead. And by the way, she signed this living will that says, in the event that I am brain dead, comatose, with no hope of recovery, I don't want to be kept alive by extraordinary measures." So actually, in the living will, there's specific language that says it has to be these circumstances, it's about end of life treatment, and that there has to be no hope of recovery. So again, it's something that you should consider executing. It's an important document. It kind of amplifies your intentions and your wishes under the healthcare proxy. I like to refer to it as a belt and suspenders approach. The belt is the healthcare proxy, the suspenders is the living will, because it kind of bolsters the decision made by the agent not to keep you alive by extraordinary measures, if that's the case, because in the living will it says that you don't want certain medical treatment in the event that you're no longer have the hope of life anymore, or terminally ill, or there's no hope of recovery. So an important document. So we've talked about really now 3 documents that have impact advanced directives vis-a-vis your healthcare and healthcare making decisions. The other advanced directive is a durable power of attorney. We like to do a durable power, not a general power, because a durable power of attorney survives your subsequent incapacity. So if I sign a durable power of attorney today and tomorrow I become incapacitated, then that power of attorney is still valid. Again, this is a writing where it's also signed, dated, witnessed, notarized, where you appoint somebody or more than one person to make and handle your financial affairs. Again, you can be as limiting as you want in that power of attorney, or you can be as broad. We always recommend them to the clients that they draft the power of attorney and agree to a power of attorney that's drafted in very broad fashion. Why? Well, the purpose of the power of attorney is to have somebody in place that can handle your financial affairs if you're no longer able to do so. So if you prepare a power of attorney and you restrict the power of the agent, then that agent may not be able to do certain things. I'll give you an example. If you don't have a power of attorney that has a statutory gifts rider, which is the current law, then your agent is going to be limited in being able to gift your assets. Well, you're probably saying, well, gee, why do I want the agent to be able to gift my assets? Well, if you've appointed your wife or your children as an agent, and they don't have the ability to gift your assets, and you become incapacitated, you've had a heart attack, you've had a stroke, you developed advanced dementia, and you can't handle your affairs anymore. Well, under those circumstances, they would be unable to do any planning to protect your assets. They couldn't make transfers of your assets for purposes of getting you on Medicaid. They couldn't do estate tax planning because it's not specified in the power of attorney. So what we like to do is draft a power of attorney that does not handcuff the agent. If you've picked somebody that you have a great deal of confidence and trust in, why handcuff them? Because if you don't have the document in place with the broad powers, and then something happens to you where assets do need to be transferred to get you Medicaid or to reduce your estate tax exposure, your agent's not going to be able to do that. And then your agent and your family members are going to have to go to court to be appointed your legal guardian, go through the expense and the delays of the court proceeding, and then basically have to wait and see if the court will approve the gifting and the transfers that they're requesting. So we like to do a durable general power of attorney with very broad powers and a very broad modification section to the power of attorney, amplifying what the agent can do, not the gifting. That's in a separate gift rider, and that's where we amplify all the gifts. The other types of power of attorney are general power of attorney. For example, you appoint somebody, but it's not durable. So if you become incapacitated, then that power of attorney is no longer valid. There's also something called a springing power of attorney. That's where you appoint somebody to act as your agent and you authorize them to act when a specific event has occurred. For example, in the power of attorney, it could say, this power of attorney shall become active and spring into effect if two doctors have certified that I am no longer capable of handling my affairs. Very dangerous to do springing powers of attorney. It leaves things up to interpretation. There's going to be an interpretation issue as to whether or not the springing event has occurred. It just creates greater potential for problems. And we do not recommend, in fact, we don't ever do springing powers of attorney because they're just too dangerous. So all the documents that I just discussed with you are advanced directives. Each of these documents, if you're an adult, you should have executed one of these documents or all of them. So the healthcare proxy, the HIPAA form, the living will, and the durable power of attorney are the most basic of the advanced directives, and we so strongly recommend that you utilize them. Thank you for your time today, and have a great day.